Donald Trump facing this deadline now approaching to secure that $464 million bond in the civil fraud judgment against him. Tonight, authorities have now taken their first steps and what the state attorney general in New York says she is ready to do. Here's Aaron Katursky.
Tonight, the pressure growing on Donald Trump as New York Attorney General Letitia James takes the first step towards seizing some of his assets if he can't meet Monday's deadline to post his $464 million bond. James filing documents to lay the groundwork to take over his golf course in a large estate in Westchester County. Trump's lawyers say he faces insurmountable difficulties in obtaining a bond. 30 insurance companies have turned him down because he doesn't have enough cash, and they won't accept his properties as collateral. Trump says the Attorney General is trying to force him to sell his real estate at fire sale prices. And if and when I win the appeal, they would be gone.
We have a lot of cash and we have a great company, but they want to take it away.
But Trump's lawyers tell the court Trump doesn't have enough cash to secure the bond, calling it a practical impossibility.
Hi guys, Adam is here. So what just happened? A court has authorized US Marshals to seize Trump's properties, including Trump Tower, Mar-a-Lago, and others worth an estimated $1.2 billion because he failed to pay or bond a $454 million civil fraud judgment. The sitting president of the United States couldn't satisfy a court debt, and now his real estate empire is directly in the line of enforcement.
So earlier this month, just about a week after the judge finalized the $454 million judgment that Trump personally faces, the New York Attorney General's office filed this judgment in Westchester County. What that means is that it sets the stage or makes it possible for her to potentially move forward to try to seize assets in Westchester. That's where he has a golf course. Also, the family compound known as Seven Springs, an estate crossing over 3 different jurisdictions. But it doesn't necessarily mean that she's going to move to seize those specific assets if it comes to that.
This is happening right now in this country, and the scale of it, the sheer historic weight of a court moving toward the physical seizure of a sitting president's assets, has no meaningful precedent in modern American legal history. None. Not at this scale. Not to a person simultaneously occupying the Oval Office. We are in territory that no American legal or political textbook has ever had to address before, and the implications will reverberate through this country for a very long time.
New York AG Letitia James making it clear that if Donald Trump cannot or doesn't pay his $354 million civil fraud fine, she'll go after his real estate holdings. But there is a caveat to that.
All right, not every building with the former president's name on it is actually owned by Trump or his companies. Fox 5's Linda Schmidt has more.
Well, Attorney General Letitia James says the property right here behind me is on her radar. It is 40 Wall Street. It is a Donald Trump property. And she says if Trump does not pay his $354 million judgment, she might be coming for it. Last week, former President Trump was slapped with a $354 million judgment, plus interest that compounds every day in his civil fraud case in New York.
Then came Trump's response. 22 posts on Truth Social in a single day. Witch hunt. Letitia James is a criminal. I will seize her house. Total war on judges. Disgraceful. The President of the United States threatening to personally seize the home of the state attorney general who successfully prosecuted a civil fraud case against him.
It was just 20 days ago that the president posted this on Truth Social, demanding that the Attorney General Pam Bondi do something about James, the former FBI Director James Comey, and Senator Adam Schiff of California. The Wall Street Journal reported last night that Trump actually thought he was sending that message directly to Bondi instead of posting it publicly for all of us to see. That mishap revealing the president was directly telling his Attorney General who he believed should be indicted. And of course, now tonight, James is facing charges of bank fraud and false statements to a financial institution. And just yesterday, we watched as James Comey pleaded not guilty in his case. The defendant table is where the New York Attorney General will find herself in just about 2 weeks from tonight. But this evening, she also had this to say moments after that grand jury handed down the indictment.
22 posts in one day while US Marshals are being authorized to move on his properties. This is genuinely one of the most extraordinary public meltdowns from a sitting American president that this country has ever seen on the record. Here is what most people covering this story are getting completely wrong. They are treating this as a standalone legal and financial story about a court judgment and a real estate portfolio. And yes, it is that. But it is also something much bigger and much more politically significant. This asset seizure authorization is landing directly on top of an administration that was already under the most extraordinary and compounding legal and political pressure of its entire existence. The Epstein contempt orders against Bondi and Patel with a jail or testify deadline running. The 130-page federal ruling demolishing Bondi's New Jersey prosecutor scheme. The unanimous Supreme Court immunity rejection that wiped out the administration's central legal defense argument. The bipartisan congressional revolt building toward inherent contempt proceedings. The approval rating sitting in the 20s. Gas prices squeezing working families at the pump every single week. All of that was already in motion, already building, already compounding before this fraud judgment enforcement situation arrived, and now the court is moving toward seizing the president's most iconic and symbolically loaded properties on top of everything else. The walls are closing in from every direction at once. The MAGA myth, the core emotional and political proposition that Trump is untouchable, that the system cannot reach him, that every legal challenge proves his enemy's weakness rather than his own vulnerability, is taking the most direct and concrete hit it has ever taken. Because this is not an indictment that gets appealed for years while life goes on. This is not a hearing that generates a dramatic news cycle and then fades. This is a court moving toward physical assets, real property, brick and mortar, Trump Tower, Mar-a-Lago, properties that are not just line items in a financial portfolio. They are the most recognizable physical symbols of the Trump brand, the wealth, the defiance, the untouchability. And a court authorized to execute on those properties sends a message that cuts through every political defense mechanism this administration has ever constructed. That message is simple. Nobody is above the law. Not even a sitting president. Not even a man whose supporters have spent years insisting the system would never actually reach him. It is reaching him right now in real time in front of the entire country, and the 22 posts cannot change that. Let's go back to how we got here. The New York civil fraud case brought by Attorney General Letitia James established through a detailed trial process that Trump and his organization engaged in sustained, deliberate fraud in the valuation of his real estate holdings over an extended period. Property values were systematically and dramatically inflated, in some cases by hundreds of millions of dollars, to secure loan terms and insurance arrangements that Trump would not have qualified for under accurate valuations. The judgment of $454 million, including accumulated interest, was one of the largest civil fraud penalties ever assessed against an individual defendant in American history. It established clearly that the fraud had occurred at scale and over time, and that real financial consequences would follow. From the moment that judgment was entered, Trump's legal team responded exactly the way they have responded to every legal challenge at every stage. Appeals filed. Stays sought. Arguments made about why the judgment should be paused, reconsidered, reduced, or restructured before any enforcement could begin. The courts at multiple levels examined those arguments and kept reaching the same conclusion. The judgment is valid. The bond must be posted. The legal process applies here the same way it applies to every other civil fraud defendant who receives a judgment of this kind. When the appeals court upheld the denial of a stay, the final meaningful legal barrier standing between the judgment and actual physical enforcement was removed. When the bond was not posted and the compliance deadline passed, the court moved to the enforcement authorization now sitting on the record, US Marshals authorized to execute on known Trump real estate holdings. Trump Tower, Mar-a-Lago, 40 Wall Street, 7 Springs. An estimated combined property value of over $1 billion registered in court proceedings. All of it now subject to enforcement action because the judgment went unsatisfied. Mar-a-Lago deserves special attention because it occupies a completely unique position in the symbolic architecture of this entire political operation. It is not just a property in a large portfolio. It is the operational and symbolic center of the Trump political universe. It is where he hosts heads of state, where he holds donor strategy sessions, where he retreats when Washington becomes unmanageable, where the inner circle gathers to make decisions, and in the minds of millions of supporters across the country, it represents the physical embodiment of everything the movement stands for: wealth, power, access. The idea that Trump operates on a different level than ordinary politicians, and that the ordinary rules simply do not apply to him. The image of US Marshals with legal authorization to execute on Mar-a-Lago to begin the process of placing that specific property under court control to satisfy a fraud judgment is an image that cuts through every political frame and every communication strategy and every outrage-generating social media post. You can frame an indictment as political persecution. You can dismiss a congressional hearing as partisan theater. You can call a poll biased or rigged or fake. It is very hard to dismiss a federal marshal's enforcement action at the front gate of your most famous property. That image, real or imminent, is doing political damage of a kind that no opposition research operation and no attack advertising campaign could ever manufacture or replicate. Now, let's talk about the 22 posts. In many ways, the response itself is as revealing about the current state of this administration as the underlying legal crisis. 22 posts in a single day. Witch hunt. James is a criminal. I will seize her house. Total war on rogue judges. Disgraceful. Fire them all. This is the public communication posture of an administration that has exhausted every substantive legal option available to it and is now defaulting entirely to noise and aggression because those are the only tools remaining in the toolkit. Every appeal has been filed, every stay has been sought, every legal argument has been made in multiple courts at multiple levels. None of it worked. So what is left is 22 posts. The specific detail that stands out most sharply is the direct threat to seize Letitia James's personal home. A sitting president of the United States explicitly threatening to use the power of the federal executive branch to seize the personal property of a state attorney general in direct retaliation for that official successfully prosecuting a civil fraud case against him. That is not political rhetoric performing toughness for a base audience. That is a documented public threat to weaponize presidential power against a private individual for doing her legally mandated job. His own words, on his own platform, permanently in the record. Here is the thing about 22 posts, though. They generate noise and outrage and counter-outrage in the news cycle dynamics that this political operation has always relied on to manage difficult moments. What they do not do is satisfy the $454 million judgment. What they do not do is post a bond that will pause the seizure authorization. What they do not do is reverse the appeals court ruling that removed the stay. What they do not do is change the legal status of the enforcement order currently sitting on the books. The noise is very loud. The legal reality underneath it is significantly louder and considerably more durable. Now, connect this asset seizure situation to the broader legal and political picture. The Epstein contempt orders against Bondi and Patel are still active. The sworn testimony deadline is still running with immediate jail as the documented consequence for non-compliance. The 130-page ruling on the New Jersey prosecutor scheme is still on the books, creating constitutional uncertainty across hundreds of active criminal prosecutions. The immunity rejection is still in force, closing off what had been the central legal defense argument across multiple active proceedings. The bipartisan push for inherent contempt in Congress is still building momentum, and now on top of every single one of those simultaneously active crises, the court is moving toward executing on Trump's personal real estate holdings to satisfy a separate civil fraud judgment. Any one of these situations would represent a defining crisis for virtually any other administration in American history. All of them converging against the same administration in the same weeks creates a legal and political pressure environment that genuinely has no modern comparison anywhere in the documented history of the American presidency. The financial dimension adds a layer of vulnerability that purely political pressure cannot generate on its own. If properties are seized, even as part of a temporary process that eventually resolves through some form of compliance, the cash flow implications for the Trump organization are real and immediate. Multiple simultaneous active legal defenses running in parallel across different courts and different jurisdictions require substantial and ongoing financial resources. When major revenue-generating properties become entangled in enforcement proceedings, those resources come under direct pressure in ways that affect the operational capacity of the entire legal defense structure. Major Republican donors who have provided the financial foundation of this political operation are watching all of this unfold with visible alarm. The donor panic leaking out of private conversations into public reporting reflects the calculations of sophisticated financial actors who understand exactly what asset enforcement proceedings mean for an organization's stability and forward capacity. The approval number reflects the accumulated polling damage of all of these simultaneous crises, landing on a public that is already experiencing genuine and sustained economic pain. The voters who supported this administration because they believed it would prioritize their economic interests and fight for them against a rigged system are watching their president generate 22 social media posts about his personal legal and financial problems on the same day that US Marshals are being authorized to move on his properties. The gap between that reality and the promises of the movement is becoming impossible to paper over with outrage and noise alone. The $454 million judgment is legally verified, upheld at multiple court levels, and the enforcement process that follows non-compliance cannot be reversed through social media volume alone. Its legal foundation has been tested at multiple levels of the court system and affirmed each time. The enforcement mechanism being deployed against Trump's properties is the completely standard process applied to any civil judgment defendant who fails to satisfy a verdict through normal compliance channels. There is nothing extraordinary or politically targeted about the enforcement mechanism itself. It is the same process that applies to every other civil fraud defendant in the same position. Trump is being treated the same way any other defendant would be treated under identical circumstances, which is precisely and deliberately the point that the court is making. 22. Truth Social posts do not alter the legal status of the enforcement order by a single dollar or move the compliance deadline by a single day. The specific properties named in the seizure authorization are not just financial assets. They are the most powerful political symbols in the entire Trump brand universe. Their potential seizure carries political consequences that dwarf their assessed monetary value. Trump Tower, Mar-a-Lago, 40 Wall Street, 7 Springs. These are the most recognizable and symbolically significant properties in the Trump brand universe. They are the physical manifestation of the wealth and power and defiance and untouchability that the entire political persona has been built around. A court-executed enforcement action on these properties sends a message that penetrates every political defense mechanism this administration has ever constructed. You can dismiss an indictment as a political attack. You cannot easily dismiss a federal marshal at the front gate of the building with your name on it. The political damage from this situation is compounding the already severe pressure on the administration ahead of a midterm cycle that was already looking extraordinarily difficult. Approval in the 20s. Active contempt orders against the Attorney General and FBI Director. A 130-page federal ruling calling out unconstitutional power grabs. A unanimous Supreme Court immunity rejection. Bipartisan congressional revolt building. Donor panic leaking into public reporting. And now, on top of all of it, a court authorized to execute on the president's most famous properties. None of these pressures exist in isolation. They are feeding each other, reinforcing each other, and collectively building a public narrative that the administration's outrage machine cannot keep pace with. The threat against Letitia James in those 22 posts is the single most politically dangerous element of the entire response, and it will generate consequences extending well beyond this specific news cycle. A sitting president publicly threatening to use federal executive power to seize the personal home of a state attorney general who successfully prosecuted a civil fraud case against him is not political theater or base mobilizing toughness. It is a documented public threat to weaponize the office of the presidency against a specific private individual in direct retaliation for that individual performing her legally mandated professional responsibilities. The James threat generated a permanent entry in the documented public record of this presidency, his own words, on his own platform, available to every journalist and political opponent and congressional investigator who wants to reference it in every accountability conversation between now and the midterms and beyond. So, here is exactly where we land. A $454 million civil fraud judgment verified and upheld through appeal. Bond not posted. Court authorizing seizure of Trump Tower, Mar-a-Lago, 40 Wall Street, 7 Springs with a combined registered value over $1 billion. Appeals court confirming no stay. 22 Truth Social posts threatening a state attorney general in a single day. Approval in the 20s. Epstein contempt orders running. New Jersey prosecutor scheme demolished in 130 pages. Supreme Court immunity gone. MAGA coalition fracturing publicly. GOP donors in documented panic. And a midterm landscape shifting in ways that grow harder to reverse with every passing week. The myth of untouchability is cracking open in real time in front of the entire country, and there is no post-volume and no outrage strategy and no witch hunt framing that can seal it back up. Whatever comes next in the courtrooms and the marshal's offices and the congressional hearing rooms and eventually the polling booths is going to tell us something fundamental about whether the rule of law in this country is real or whether it only applies to people who cannot afford enough lawyers to delay it indefinitely. The legal walls are closing in from every direction simultaneously. The financial pressure is real and immediate and documented on the court record. The political damage is compounding faster than the administration can respond to it. And every day that passes without resolution adds another entry to the permanent public record of exactly what this moment looked like from the inside. This is the convergence point. Every legal battle this administration has fought, every constitutional limit it has tested, every court order it has defied, has been building toward exactly this kind of moment where the consequences become impossible to delay or dismiss or absorb through noise alone. The system that Trump has been at war with is now executing against him on multiple fronts simultaneously, and the country is watching every single move in real time.